welcome back po ulit. Welcome back to LIRA in Law. Today, the 27th of July. The last Thursday. Sorry, sabi ko July. June pa lang tayo, no? I'm getting ahead of myself. 27th of June, which is of course the last Thursday. I think last Thursday nga of June. 1 week to go. We of course have our general election, no? So if you can vote, you should vote, no? And let's see what happens. Exciting times in the world of politics. Probably the nicest way of putting it. So welcome po ulit to LIRA in Law. I'm your host, Lira Simon Kapat. Now, my apologies again for being a bit late now tonight. So we're going to, without further ado, we're going to launch into our topic, which is nga wills, or should you make a will, no? So let's go into it. All right. So unang-una po ito. Let me read to you an article that actually I came across a couple of days ago. No, it was carried out. It was research carried out by one of the large policy providers, insurance providers. No, so let me just read to you briefly. Anong sabi nga nila? So sabi nila ito: half of UK adults do not have a will. No, half. The survey, based on 2,000 UK adults, revealed that 1 in 3, so 33% of adults who are aged 55 and over do not have a will in place. So a big chunk of that are people who are over 55. The research found that the belief that they do not have, the belief that they do not have enough assets or wealth toward making a will. So ito mga dahilan, why don't people make a will? They don't think that they have enough assets or wealth nga to make a will. 24%. And 17% think that well, hindi naman problema. No, their loved ones will automatically inherit their wealth. 17% of people thought that. Other reasons for not making a will are things like, well, they can't afford it. No, 15% of people thought that. Another 15% believe that they have plenty of time, no rush nga, no, and then 14% it's a question of knowledge. No, they don't know how to write a will, so they don't know where to begin, for example. So and then the further 13%, so 1 in 7, they don't want to think about it. No? They don't want to think about it because they don't want to talk about death. So those are the common reasons nga why people don't make a will. Now, ang topic po nga natin ngayon, should you make a will? And so let's look at those concerns, no, those reasons nga nila. So now, una nga, the 24% of people surveyed nga believe that they do not have enough assets or wealth toward making a will. Now, a will, of course, if kung marami kang pera, then it could be argued, I mean, I don't actually agree with it, but it could be argued that you should make a will kung marami nga kang pera. Wala kang pera, I suppose the converse is arguable, that what's the point? That's actually incorrect. Unang-una po, you can leave in your will what they call specific legacy. No? Ibig sabihin, kung meron kayong relo na gusto niyong bigay sa anak niyo, sa apo niyo, no? O meron kayong kotse na gusto niyong bigay nga sa kapatid niyo, no? So it doesn't have to be anything valuable. It can be a specific thing that is to you has sentimental value, no? So for example, I'll give you an example, no? Meron akong kliyente nga he wanted to leave and he left in his will nga his tawag nga niya, my old banger, yung sabi niya, which is an old car. No? It's not a valuable car. Ang dahilan niya, so he wanted to leave it to his friend. Dahilan niya, because he was always getting wound up by his friend because of his old car. He just didn't replace it. He likes his old car, sabi nga niya na. And so he wants to leave it to his friend because it's in the hope nga that he would remember him, no? Remember all the times nga that they were joking around about this old car. So it's not. It doesn't have to be anything, anything expensive, anything valuable nga. You know, ang iiwanan nyo. Of course, kung meron kayong pera, then I'm sure your family would be happy to receive it if you want to leave it to them nga. But it could be anything just special to you. It's not valuable, but it's simply special. No? And so it's not. It doesn't have to be. You don't have to have great wealth or even wealth, no? In order not to make a will. It's kind of nice, no? That it may be one of the last documents they hear from you about, you know? And so it's kind of nice, I think, to be able to say, oh no, and they remembered me. So this business about, you know, the survey showed 24% of those people surveyed, sabi na, they believe they do not have enough assets or wealth. It's actually not quite the correct way of looking at wills, no? Now, in the same survey, nga sabi na 17% of people surveyed believe that loved ones will automatically inherit their wealth. Now, this is quite, this is probably one of the more most concerning, no, belief. So hindi tama eh, no? So tingnan natin. Let's say you did not then leave, you did not make a will, no? And dahil kala nyo, your loved ones, no, will get it automatically. So let's just unpack that a little bit. So sabi nga nila, okay, so someone who dies without a will, no, is commonly referred to as having died intestate. So basically wala silang will. Kung ganon mangyari, their estate, so whatever you own, to a point, will go to beneficiaries, mga taong that would benefit according to what they call intestacy rules. No? Wala nga kang will, so it will titingnan nila yung batas, and they will look at intestacy rules. Now, let me just give you the list of beneficiaries, okay? So wala nga kang will, who will benefit? So tingnan natin. So unang-una po, so it will go to one first, and then the second one. Kung wala nga, there's no one, no first beneficiary, and it goes to the second beneficiary. So it follows through. There are, of course, fixed limits nga also about money that you can that they would receive as spouses. You can look at that also a little bit. But basically, ang lista po ito. Unang-una, on the intestacy list, spouse, no? Spouse or civil partner. So, kasal kayo, asawa nyo, no? A civil partner, of course, is if you've entered into civil partnership na with your partner. Then, what they call issue, basically anak, no? So your children, and then parents. So issue nga yung parents, no? Magulang niya, of course, no? Brothers, sisters, no? Grandparents, uncles, aunts, no? So those people will then benefit. So kung wala kang asawa, then it goes to, for example, meron kang mga anak, it goes to the children nga. There are, as I say, limits, no? Kung if your assets are over a certain amount, £322,000, it could be that it does not anything over then goes to the children. But yun ang lista. Now, the problem sometimes is this, and this is something that unfortunately I've had to advise on clients. And sabihin natin, meron kayong partner, no? Hindi nga lang kayo kasal, okay? So hindi kayo kasal, you never bothered, for example, you didn't think it was important, o kaya kasal kayo sa atin. That also certainly happens nga. So sabihin natin, that's exactly what had happened, no? So if you're not married, anong ibang nangyayari dun sa partner nyo? What will happen is, unfortunately, under the intestacy rules, there are maybe other provisions, but under the intestacy rules, they will not inherit. There's no such thing as common law spouse. So, ibig sabihin, wala silang makukuha under the intestacy rules. Now, of course, if it's all agreed, then walang problema, then great, no? But oftentimes, that's not the case. So, it could even be na merong kasal kayo sa atin, no? Meron kayong asawa nga sa atin, and that may be why you never married in the United Kingdom. You never divorced, you never married, no? In the UK. So that would then mean that wala siyang makukuha unless they can make an application under a different provision. no? Because of the fact na nagsasama nga kayo. But otherwise, they don't get anything. Now, that can be understandably distressing, and to also be, sometimes I've had unfortunate task of saying to people, yeah, unfortunately, under the intestacy rules, you're not a spouse and you're not a civil partner because you're not married, you're not in a civil partnership. So unless we can show that you come under a different provision, then there's nothing, you won't get anything under the intestacy rules. And that can be really unfair and very distressing. I mean, of course, it's again different if you own a property and you own it as joint tenants rather than yung tenants in common. And so it could be that you, if you're joint tenants nga, that you would get it automatically, but don't rely on that. It can be quite, as I say, quite distressing. And clearly, yung akala nyo na it means, your loved one will, loved ones will get it automatically. It's not automatic. So now, also, 15% of people surveyed, sabi nga nila, they can't afford to make a will, and also they don't know how to write it. So they can't afford to make a will. Well, will costs vary, and depends really also kung anong how complicated it is. Are there assets abroad, for example? How big is the estate? So, but you can shop around. Wills need not be expensive, but of course they will, and just, yeah, as I say, shop around. Importante nga lang that whoever you instruct should be, like in any area of law, should have the expertise now to do it. Okay. As to how to write one, now, okay, cool. What your solicitor will ask you, what we certainly ask clients, are a number of things, and they're not difficult questions also. So una nga, you need what's called an executor or executrix. And they are the ones in charge of gathering the estate. Okay? So kung may mangyari nga sa inyo, silang susulat sa bangko, silang susulat nga sa, if they need to appoint solicitors, then they appoint nga sa solicitors. So basically, they're in charge. They don't have to be they do not have to be the beneficiaries as well. We'll speak about beneficiaries in a moment, but certainly executors play an important role, because they're the ones who are organizing, the estate nga. Then, of course, so yun ang una. And beneficiaries, of course, they're important. Who's going to benefit from your estate? Okay? So, sinong gusto mong bigyan ng pera? O kaya yung relo? O kaya yung kotse? So, your beneficiaries can receive nga, well, they can be apo nyo, so they're under the age of 18, in which case they would need really trustees to deal with their share. O yung asawa nyo, o kaya yung girlfriend nyo, all right, o boyfriend nyo nga. So it's so they could be any beneficiary. It could be a charity, if you want to. Now, kung meron kayong mga anak, important also is guardians. Okay? Usually, kung meron yung nandiyan yung amay o ina nga nila, that they would be then, of course, guardian. Kung wala na sila, then you may want to appoint someone else to look after them in the event that you die whilst they're still under the age of 18. And of course, again, you need to be able to trust them na talagang aalaga nga yung mga bata. And equally as important is the estate. Ibig sabihin nga, the estate is what you own generally. Okay? So things like bahay, as I say, kotse, o kaya relo, so a jewelry, so you have the residuary estate, so kung anong natira after payment of the specific, the pecuniary legacies, yung pera nga, specific legacies, things na, as I say, items that you want to bequeath to someone else, to loved ones nga. So those things, that's the estate. So generally what you own. It's a bit more complex than that because there are things like jointly owned property, but otherwise estate is exactly that. What do you own? Now, if you have all that information, so for us, we ask those things of the client, then the will is prepared. Importante nga din, it's of course properly considered by you, that you're happy with it. If there's something not quite right, make sure that you raise it with your solicitor nga. And then it needs to be witnessed. Now, there are strict process now for witnessing the will. And you would require 2 witnesses. They must be there when you sign, and you must be there when they sign. Importante nga yun. Otherwise, you may find that your will is not valid for want of execution, no? Because you have not executed it properly. And kung meron kayong abogado, they will be able to take you through also the process. So it's not in the scheme of things. Wills are very important, of course, no. But in the context now of legal documents, it's probably not as if you like complex as other documents. Pero importante pa rin. If not, if I would even say that it's probably one of the most important documents you can execute, during your lifetime, because that's it allows you certain things. It allows you to, of course, say what you want to happen upon death. It allows you to provide for your children, guardians for example. It may, in some cases, it can allow you to do some tax planning, okay? But it doesn't even have to necessarily be, but it's kung malaki marami kayong pera, it's probably a good idea to also consider that. So all those things you can put in your will, okay? And it is important that you consider it and read through it. If there is something you don't quite understand or you don't agree with, if you have solicitor preparing it, raise it with them. Okay, mahiya, no? Now, because of course we have viewers now from the Philippines, and there are also and viewers, of course, in the United Kingdom who have assets in the Philippines. Let's just deal with that. Assets abroad, or assets in this case in the Philippines. So tingnan natin, okay? Now, again, it's quite complex, but basic issue is succession. So you inherit succession to immovable properties, so real estate, lupa, bahay, okay, will be governed by the law of the country in which that land is found. So nasaan? So kung meron kayong lupa, meron kayong bahay sa Pilipinas, then the jurisdiction that would deal with that, so sino makukuha nun, so sa kanino maiiwan nga yun is the law, the Philippine law, okay? So importante yun. If you're making a will nga in the UK, and akala nyo making a will here means that you are able then to leave assets nga na nasa Pilipinas. Well, by that I mean land in the Philippines. That's not the case. Okay? So Philippine land, house and lot sa atin, you should make a will in the Philippines, or look at other provisions in the Philippines, because your will in the United Kingdom will not deal with immovable property, so real estate. Now, by contrast, movable property, so ibig sabihin so for example, shares, bank accounts nga abroad, usually yun, they look at the individual. So ako, the individual country of domicile. Dito ako nakatira, sa England, and so they would look at the law that governs in England, and so if I have an account now in the Philippines, that means that English law can be applicable, or likely to be applicable, in relation to the account now in the Philippines, for example. But it doesn't have to be. So it can be quite complex. So if kung meron kayong pera sa atin, meron kayong account nga sa atin, at saka may bahay lote kayo sa atin nga, it may be an idea to seek advice specifically for properties, assets nga in the Philippines. So prime example, for example, is and this is something that actually I come across with some regularity. Sabihin natin dito kayo nakatira, kasal kayo sa atin. Now, what then happens is that you never divorce your wife in the Philippines, but you're living together nga with someone in the United Kingdom, or sometimes you did divorce your wife in the Philippines, or your husband nga in the Philippines, remarried in the United Kingdom, okay? But unfortunately, at least at the moment, It could be that your marriage in the UK is not recognized now in the Philippines. And so what could happen then is kung ano man assets nyo sa atin, the immovable property, it could be that that goes to your husband or wife in the Philippines, who you have divorced in the United Kingdom. And that can be quite unfair because then you thought, well, that it would go to your wife or husband, second wife or second husband in the United Kingdom. So it's it can be quite complex. So if you have assets nga in the Philippines, probably best to seek advice in relation to how best to deal with those, especially nga if they're immovable property. So as I say, lupa, bahay, accounts should be covered by wills nga in the United Kingdom, but again, be careful because it could be that banks sa atin nga may take issue with the validity still of wills, especially if they're competing interests. By that, I mean, sabihin natin, meron kayong asawa nga sa atin, sabi niya, oh no, in the Philippines, we never got it annulled. And so because of that, I am actually still his wife in the Philippines, and therefore I'm entitled. So be careful, and all of those things nga can, in many ways, you can't cover everything in a will, unfortunately. And even with wills, there could be disputes nga later on. But you can try and cover as much as you can. But if you don't address it all together, ang mangyayari, kung wala nga kayong will, it could be then that it goes through intestine. What then happens is exactly what you don't want to happen going forward. Because you want people nga who you love and you care for nga to benefit. And it would be a great shame if that does not happen for one document, which is your will. So the top, as I say, top topic nga natin ngayon is, should you make a will? Absolutely, you should make a will. It is, and if you make a will today, nagbagong isip nyo, sabihin natin, actually, the relationship that you have in the UK or mga anak nyo, tumanda na sila, you can always make a will. There's no a new will, that is. So you can, there's no limit as to the number of wills you can make. But and anyway, you should also review it on a relatively regular basis. Ang payo ko sa mga kliyente ko, just give it some further thought, maybe once a year. You don't have to change it every year. Some people do, but you don't certainly have to change it every year. Actually, I was preparing a will for someone whose first will was made some 20 years ago. Okay? So you can do that. Just give it some thought. If you want not to change your will, to change the provisions, you should always keep, of course, the original. Importante nga yun, either keep it with your solicitor, you can put it in their safe, or indeed, if you have a safe, put it in your safe. But you should also just have a what they call soft copy, or digital copy. So importante po yun. So the quick answer to the question I posed, now, should you make a will? Absolutely, you should make a will. Now, I hope that was of interest nga to you, and that you enjoyed it. It's a little bit different now from our usual topics, but because I thought we'd change it up a bit. Now comes the part of my favorite part. Alam ko, sinasabi ko nga ito lagi, the batian part. And so let's just